All right. Good evening, everyone. Calling together tonight's planning board meeting for October 1st, 2024. First, we're going to do want to say that this meeting is being recorded. Those in attendance that have a question for the board during their interested application, you can raise your hand. Mr. May will allow you to speak. We'll start with the roll call. James Sweeney.
Here.
Matthew Payton.
Here.
Marty Kroll.
Here.
Yolanda Spinola.
Here.
Tony Gonzalez, present. Okay. We have 90 Leyden Park added to the agenda tonight, but they're going to ask for a continuance when we get to this one. We have a continuance request for property Field Street and a continuance request for 244 and 252 Warren Ave. We're going to start off with a review and acceptance of last month's meeting, please. Is there
Motion to accept September minutes.
Second.
All right, roll call. Matthew?
Yes.
James?
Yes.
Marty?
Yes.
Yolando?
Yes.
Tony? Yes. All right. Next, Evan, sorry, do you have a lot release for Augusta Estates?
We do, yes. We are currently holding 8 lots. They have done enough work to request 5 of those lots, lot 5, 6, 10, 11, and 12. The board will be holding 3 lots after this to cover the rest of the work needed, which is plenty to cover that.
Okay, is there a motion?
I was just going to say, Madam Chair, just for the record, I have an email from Councilor Shirley Asack expressing her support for this project.
All right, thank you. Is there a motion?
Motion to approve.
Second.
All right, Matthew?
Yes.
James?
Yes.
Marty?
Yes.
Yolanda?
Yes.
Tony? Yes. Okay, Evan, sorry, do you want to go ahead with the surety for 340 Warren Ave?
Sure. So currently the board is holding a $100,000 bond for surety for 340 Warren Ave. They
10,000.
10,000?
You just said 100,000.
Oh, I thought it was 100,000. Okay. Well, we have a bond for
it is?
that property. Anyways, we have a bond for
shut
that
up.
property. They provided an as-built. We inspected it. They are pretty much done with everything. The only thing they missed was some landscaping. So the board can release the surety with the exception of the required amount to cover that landscape, the trees and basically trees and everything. We don't have the exact number for what we need to hold still. That should be coming in tomorrow morning. So if the board is comfortable with that, you guys can vote to release the surety, holding back the required amount.
And Madam Chair, I have seen the quote. Unfortunately, when he emailed it to me, it was password protected, and so I couldn't get it back out. So I know it's a legitimate offer. I think it was either 1,300 or 13,000. So
That's a big difference.
big difference.
Yeah.
But we can take, if you move to release the surety minus the amount for the landscaping, and we can fill in that amount, it should be a clean motion.
Okay. Is there a motion?
Motion to approve.
Minus the
minus-
landscaping.
Minus the amount for the landscaping.
Minus
Thank you.
landscape. Second.
Second.
Okay. Sorry about that. Matthew?
Yes.
James?
Yes.
Marty?
Yes.
Yolanda?
Yes.
Tony? Yes. All right, Mr. May, are you up next for the form-based code zoning draft introduction and overview?
I believe I am.
All right.
And can you all see my screen?
Yes.
Form-based code and the Brockton MBTA communities compliance. This is a brief overview of the MBTA 3A Communities Act and the zoning that the planning board is proposing. We will be submitting a zoning proposal to city council at their next meeting. That will then be referred back to you and to the ordinance committee. You will both have your own hearings, and the planning board will report back to the city council. Hopefully that it's favorable. We've been working on it for a long time. And then council will have their vote before the end of the year. So the MBTA Community Act was developed by the Commonwealth in 2022. And it was a way to create multifamily housing in MBTA communities. There's a lot of old zoning in the 100 and so communities that are served by the MBTA that excludes multifamily housing, especially around the train tracks. And it just doesn't make sense to allow for low density development around transit options. The act is referred to as MBTA 3A. It's section 3A of chapter 40A in the zoning code, or in the state code. There are some requirements for that, including that our zoning we need to have a district of substantial size, and they've determined that to be 50 acres, that allows multifamily by right at a density of about 15 units per acre. There are some other requirements along with that, but they have, in Brockton's case, we need to have 90% of that district within a quarter mile of the MBTA stations. And we need to be in compliance by December 31st of this year. We were able to get some technical support from the Commonwealth and our partners at Mass Housing Partnership. And that has helped us over the last 2 years come into where we are right now. The first thing we had to do was evaluate our zoning to find out, were we in compliance? Or was it something that could be tweaked relatively easy? And the answer was no, we're not in compliance. We developed a plan, Evan, I should say, developed a plan to come into compliance, and it was accepted by the Commonwealth. And so over the last 2 years, we've been engaging the public and select elected officials to develop this zoning proposal. We've been meeting in downtown where and Trout Brook, where we have a master plan in place already. And we completed a master plan for the Campello neighborhood last year, and now are converting that plan into new zoning. Through all these public meetings, and there's been dozens of community meetings and encounters over the last 2 years, we've heard from the community that they want something bolder. They want to make sure that what happens in their community is what the developer is selling them, and that our analysis was that our current zoning doesn't offer those kinds of guarantees. And so what we've proposed is a new series of form-based code districts and regulations that will implement our MBTA 3A compliance. What is form-based code, you ask? Well, form-based code is a land development regulation that fosters predictable building results that have a high quality public realm. Public realm is the street scape and the areas that are accessible by public, that use the physical form in addition to the separation of uses to help organize the principles of this code. For example, you see in this diagram below, or this illustration below, that under conventional zoning, you usually get some measurements about density, floor area ratio, setbacks, et cetera, et cetera. And what you get is a building box, which is on the left-hand side. It's fairly nondescript, but it says you can't build outside of this box. as you can see from that diagram or that drawing, it's not very imaginative, and God only knows, what is going to end up in that development. And, the residents want a little bit more surety. So we looked at zoning design guidelines. Well, that's nice. It tweaks around the edge, but guidelines are optional. They're not mandatory. And so you might get one design that's presented and you end up with something that's completely different or slightly different. And then form-based code, we're basically looking at how the buildings interact with each other and interact with the street, in addition to what's going on in those buildings. And you get a much more fine detailed planning process, and you get the buildings that the community is expecting, and you get the uses that the developers need out of this process. So why are we choosing to float form-based code? And this is a new kind of concept for zoning. We've had our traditional zoning that separates by use, and it says, industrial's over here and commercial's over here and residential's over there, and none of them should mix with each other. But that led to a lot of suburban sprawl and a lot of development that is not healthy, financially healthy for our communities. And so by creating a form-based code, we're providing some relief to developers by giving them more flexibility, both in the number of by right uses and other regulations, including the special permits, where are easy to issue than variances. It encourages historic preservation and adaptive reuse. Just as importantly, it provides residents with predictability. They know what they are going to get once we've approved it. So there's no opportunity for bait and switch. They create great walkable neighborhoods, and they create vibrant places with good jobs, good services, good housing. As I said, we've been studying in a couple of different areas. Downtown Trout Brook was the first one. Campello is the second. We have been working over the last 2 years in an area called Lovett Brook, which is the area around Good Samaritan Hospital. And then we've just started a master planning process in the Campello neighborhoods. And this zoning is flexible enough that we could look at it in other areas once it's adopted. And that could be the fairgrounds. It could be the Massasoit Conference Center. As I said, it's fairly flexible, and we've written it with enough with the idea of being able to expand it into other neighborhoods. And so how does form-based code work? Well, in our case, each lot will be mapped into one of 9 specific districts. And there are 2 residential districts, there's 3 mixed districts, and 3 commercial districts, or including an industrial one. Now, I've done the math, that doesn't come into 9. Our 9th district that I failed to put on there is civic. And so institutional uses like City Hall or a public library or a park, instead of being zoned, residential or commercial, and we now have a civic category to protect those land uses. And then each of those districts has a different type of permitted building form, which is where form-based code gets its name. And permitted buildings, the forms, the types of buildings are not like an architectural style. We're not saying, oh, they've got to be colonial. Oh, it's got to be, traditional New England bungalow. It means things like a form would be a single family residential building, a duplex, a mixed use building, a big box retail store. Those are all the different forms, and you'll learn more about that as we go through there. So each of the districts also has a series of by right uses, and uses that require special permits or uses that are completely prohibited. There's also defined standards and characteristics that go with each of those districts. And then Further down the line, each building form has its own defined lot and building dimensions, mass, and design guidelines or design standards. So in our case, let's use an example. We have one of our new mixed districts, which we've called MX1. There's 3 building forms that are allowed within this district. One is an apartment building, which we've changed the name to residential building. You could have a mixed building or mixed use building, or you could have a commercial building. MX1 allows for a 3-story building, but if you use and provide the city with public amenities, you could go up to 4 stories with a special permit from the planning board. There are by right uses that go along with that, including residential, retail sales, food and beverage, office, things like that. But it goes to prohibit very specific activities like vehicle repair, industrial, or major utility facilities. We'll take a look at the mixed use building, which is one of the building forms that's allowed in the mixed district. So this type of building is allowed in MX1, 2, and 3. And the difference between those is that MX1 allows for a height of 3 stories with a bonus to get to 4. MX2 would be a minimum or would be a maximum 5 with a bonus to get to 6. And then MX3 is a maximum of 7 with a bonus up to 10. And when you see the zoning map in the next presentation, it'll make much more sense that these areas are around the train station, have their back up against the tracks, and where you want a larger building to both support economic activity, housing, and provide a buffer between the neighborhood and the rail tracks. So each building has its own lot requirements, including building and parking setbacks, a green score, which we'll explain as we get further into this. There's lot coverage and open space, and then there's requirements for surface parking and structured parking setbacks. It depends on what district you're in. There's also building requirements. There's a minimum and there's a maximum number of stories, which we've discussed, but there's also a new concept where there is a minimum number of stories. Brockton land is too valuable to allow lower density development in these districts. And so if your maximum height for example, is a 3-story building, your minimum height would be 2 floors. We want you to add value. If you're going to be buying and developing property in these districts, you should be adding value to the community. There's also requirements on the facade composition, the number, where the windows are placed, and how the blank walls, how large of a blank space you could have. There's a minimum number of floor heights, floor to floor heights, so that we can encourage ground floor commercial redevelopment, to make sure that we have the proper floor heights to attract modern retail facilities, but also to make sure that when we're building residential buildings, we don't have these small apartments where I can touch the ceiling. In a situation like that, you're really trying to cram as many people into a house, and that's not, or into a building, and that's really not what Brockton residents have told us that they want. There's also requirements for amenity space, both indoor and outdoor amenity space, and that we will discuss in the next presentation. So there's interesting concepts that we're developing. We just talked about the minimum number of floors per district. There are now going to be standards for parking relief by special permit. So no more going to the zoning board of appeals and just trying to negotiate your way out of it. If you're going to and need to reduce parking, there's a series of tasks that the property owner needs to accomplish to get down to that particular number. We're talking about a new curb setback, and this is something that we don't have right now. We have usually a property line setback, but as we redevelop in these higher density districts where we're going to have taller buildings, we want to have wider sidewalks. We also have streets that are faster and see a lot more traffic. So wider sidewalks with more amenities provide an extra level of safety for people who are walking in the community. And so there is a setback that is measured from the curb. So most sidewalks in Brockton are in these downtown areas are 8 feet or so. By setting it back an additional 8, let's do the math, 6 feet, we get to a 15-foot wide sidewalk. And that's depending on the size of the street, and whether it's a primary street, secondary street, or a transitional street, determines the size of the sidewalk. And so primary streets have a 15-foot sidewalk. And they also have a greater activation, ground floor activation. We're proposing to unbundle residential parking. So if you are looking for an apartment in downtown Brockton and you use transit and you don't need to use parking, it's not going to be included in your rent. However, if you do need parking, then you'll have to pay for parking. So right now, there's a lot of people who don't have cars, but they are, through their rent, paying a proportional share of everybody else's parking. And that's kind of raising the rent rates and kind of making some properties unaffordable. And then we talked about the outdoor amenity space and indoor amenity space. So we've tried to anticipate what some of the concerns are going to be about form-based code. And one of them right off the bat is there's too much regulation. When you see this document, it's 200 pages. But it's true that there are a lot of regulations, but in the end, there's a lot more flexibility for the developers. So they are getting a little bit more regulation, but they are getting back from the city more flexibility, higher heights, more uses by right. So it's sort of a give and take situation here. People may say that there's more upfront work for developers. True, but the exchange for that is that residents will be more certain as to what they're getting. It's too expensive to do. Well, that's a fallacy because you're going to have to produce these plans to build and get a building permit. So why not just do it now? There has been hesitancy in the past. If you had to go for a zoning variance, you didn't want to spend that money up front and get shot down. Now that there's more uses and more options available that are by right or through a special permit process, it kind of makes sense to go ahead and do that planning up front so that we, the community, know what we're going to get. And then there might be a little, some people said, well, there's little opportunity for community review and comment. Well, we've designed this new zoning based on the comments of the community. So they've already had a lot of input into this, but applications will still need to come forward to the planning board to go through site plan review or to get special permits. So there's still going to be public notification, even though there's a lot of stuff that's by right. There's still going to be a lot of public notification, and there's at least one public hearing in front of the planning board to get your permits. And that is the end of my presentation.
All right, thank you, Mr. B. Any questions from the board members?
So just one last thing. Once we introduce this to City Council, it will come back to you. There will be another series of recommendations. I do want to thank the planning board members who have served on some of our advisory committees, including the chair and Jim Sweeney. We've also had several counselors serving on this, including Sue Nicastro and Jeff Thompson have been very involved. And we think that we've got a great product that is modern zoning for a modern Brockton. So I'll leave it at that.
Thank you. So we're not going to vote on this tonight, but do you
No,
have any
no.
questions?
If the board has some questions, we'll take a swing at that. It's not a public hearing, so we're not taking questions from the public at this time. But when we do have our public hearing, we will be doing that. So if there are board member questions, I'd be happy to try to answer those.
Madam Chair, could I say something?
Sure.
Well, but I don't have any questions because I went to a recent meeting that was
Oh,
held
yes.
at North Middle School. And I was impressed. I was impressed by the number of members of the public that were there. A lot of them, I was especially interested in close to where I live, which would be the Lovett Brook. And I met a lot of those residents who were very well versed on what was happening. They did have some
you.
questions and obviously, but they had been included in the process and I thought that was pretty impressive.
Thank you.
And it's a whole new way of looking at, we're not just waiting for someone to come along and say we want to build. We're planning it out ahead of time, which is
Yes,
in my day kind of unheard of in the city, if you don't mind me saying so. So I was impressed. So thank you for all your work.
thank you, ma'am.
All right,
And I've got
anyone
to
else?
thank Evan and DeRay and John Fay, who have been coming out on Saturdays to public meetings and events in parks with, the Cape Verdean Association at Cape Verdean Day and the Haitian Community Partners and a pop-up event in the Campello neighborhood in the rain. We had another business meeting in Lovett Brook in the rain. That was a lot of fun. But they're dedicated to this and I really appreciate their support.
All right, so if there are no other questions, we'll continue with the agenda.
Thank you very much, ma'am.
You're welcome. I'm just gonna move around a little bit and start with the applicants who have requested a continuance. The first one is Field Street. Is there a motion?
Motion to continue approve.
Second.
Okay, Matthew,
Yes.
James,
Yes.
Yolando,
Yes.
Marty,
Yes.
Tony, yes. All right. The next one is 244, 252 Warren Ave, return to ZBA, requesting a continuance. Is there a motion?
Motion for continuance?
Second.
Okay, Matthew,
Yes.
James,
Yes.
Yolando,
Yes.
Marty,
Yes.
Tony, yes. And then one last.
Madam Chair, I'm sorry, I just want to interrupt for just one second. I did receive an email from John Andre. The remaining balance for the trees is $5,500. So just so that's on the record and you all know.
Okay,
So thank you all.
thanks, Rob. So the last one requesting a continuance is 90 Layden Park, definitive subdivision. Is there a motion?
Motion to continue.
Second.
All right, Matthew,
Yes.
James,
Yes.
Yolando,
Yes.
Marty,
Yes.
Tony, yes. All right, next up is extension request for Petronelli Way. Representative JK Holmgren Engineering.
I'm moving Scott over. He's on his way.
Good evening, Madam Chair. Good evening, board members.
Hey, Scott.
Scott Farrier from Holmgren Engineering.
You look different, Scott.
Thank you.
You shaved
think
it off.
Yeah, my wife said I was looking old.
Scott, more handsome than ever.
Thank you.
I thought it was the light that made it look like a halo. I wasn't buying
Oh,
it.
boy. All right, all right, all right. All right, let's get to business, Madam Chair.
All right.
But thank you, Marty. So we were before you folks a couple of months ago for a modification for Ringside for Joe Gonzalez on Petronelli Way. And we forgot to request an extension from our planning board site plan approval. We received site plan approval back in January of 23. So it'll be running out shortly. So Joe just wanted to get on the agenda and get an extension just so we can proceed with our construction schedule and get things rolling on the project.
Okay. Any questions? All right, and this is not open for public, correct, Rob?
That's correct.
No.
Okay, all right, is there a motion?
Motion to approve extension. Second.
Second.
All right, Matthew,
Yes.
James,
Yes.
Marty,
Yes.
Yolando,
Yes.
Tony, yes. All right, thank you, Scott.
Thank you, folks.
Thanks, Scott.
All right, we have returned to ZBA 37 Lawn Street.
Let me see.
I think we have
So-
Attorney McCluskey on this one, Madam
Yeah,
Chair.
he's the phone number. I don't know if we can move him over. We might just have to allow him to talk. I did just email him another link for him to try. So if you can hear me, check your email real quick. And if not, you are allowed to unmute and speak, Attorney McCluskey.
While we're waiting, Madam Chair, I'm just going to share the screen and put up a plan of the Lawn Street property.
All right, thank you, Scott.
There you go. I think while we're waiting for Attorney McCluskey, I think I'll just give you a quick. Oh. Was that him?
I don't think so.
Well, let me just do the best I can to struggle my way through it, folks, and hopefully Attorney McCluskey can get on and undo everything that I do while I'm talking here. So we were before the Board of Appeals more than a year ago for the plan that's in front of you. We were hoping to divide an existing property into two lots. There's an existing house at 37 Lawn Street, and the property. There's Attorney McCluskey. The property is shown as one plot. It's shown as plot number 5 on the assessors map. It comprises two lots on a planning board plan that was way back in the 1880s that divided a whole bunch of property, and then the plot number 5 in the assessors reference comprises lots numbers 12 and 13 on that record plan. So we were going before the Board of Appeals to receive permission to construct a house on lot 12 that you see in front of you. The main reason for the denial at the time, we kind of felt it was a little bit of a procedural issue, whereas now we're coming before you folks with a definitive subdivision plan to divide these lots, and then we go to the Board of Appeals and hopefully they give us a variance for those lots to become buildable. Back when we did this one a year and a half ago, we weren't doing it that way. So the ZBA felt like because the lots in their mind didn't exist, they couldn't hear the case. And as such, they denied the case. In the meantime, we've gone, as you folks know, we've gone round and round with the building department, with the legal department, and one way to create the lots, it was determined, was to create deeds at the Registry of Deeds that would divide the property. So Attorney McCluskey has now recorded deed descriptions that divide the property into two lots that are shown before you now, lots 12 and 13. So we're simply asking you folks to grant us permission to go back to the Board of Appeals with the feeling that we've addressed their main reason for denial, and to get a hearing back before the Board of Appeals to try to make lot 12 a buildable lot. And I don't have the actual ZBA denial in front of me, Madam Chair, because I was anticipating Attorney McCluskey. would have it and would be making that part of his presentation. So I apologize for not having it.
Right, and so Scott, why was this originally denied?
As I recall, Madam Chair, we felt like it was a procedural item. The lot wasn't divided before it went to the Board of Appeals. As we do now. Currently, we come before you folks with a definitive plan creating, in this case, we would be giving you a definitive plan that creates 2 unbuildable lots. We would then get your approval, go to the Board of Appeals the next month and say, okay, the planning board created the lots. Now you folks can grant the variances to make it a buildable lot. Back a year and a half ago, we weren't doing it that way, and it was denied basically on that because the lots, in the opinion of the Board of Appeals, the lots did not exist at that point. So they didn't feel like they could act on a variance on lots that did not exist. So in the meantime, Attorney McCluskey has recorded the deeds that create the lots. So right now, lots 12 and 13 exist at the Registry of Deeds.
Okay, Mr. May, can you remind the board of the requirements for a substantial change?
I'll take that, Madam Chair. So, I have the ZBA letter here. Their decision, and I just want to point out that it looks like Attorney McCluskey is back in the attendees, and I've given you the permission to unmute. So if you can unmute again, Attorney McCluskey, feel free to jump in. They were denied per the official ZBA decision for not having any evidence or elements regarding Mass General Law 40A Section 10, which is related to hardship, which is topography, shape of the lot, or soil condition. And then they also, it says there was an absence of evidence that 2 individual lots existed based upon research of numerous prior deeds showing one set of Metzim bounds. So basically, they didn't agree that they were 2 lots on record, nor did they think that the applicant had provided sufficient evidence for the zoning board to grant them a hardship, which is required to get a variance. So that's the official basis for their denial.
And so with the lot now divided into 2 unbuildable lots, does that now change the lot shape?
So there's this. So Scott, you said that you guys were doing a definitive, but this isn't a definitive yet. This was only via deed. And
Correct.
there was confusion you said about a year and a half ago, and we had a meeting with a bunch of different departments,
Right,
and developers and everything. And there was a determination that lots could be split via deed, not through a subdivision.
right.
The law department was a little iffy on that, so they wanted to double check. But it turned out that only applies when it's basically an A&R. So pretty much if the frontage is there, when you could otherwise do a A&R, basically you don't need approval through a subdivision process. That's when you can do it through deed. And I tried to clarify this, I know, with Attorney McCluskey a couple times over the past, like I know I sent a clarification email last January about this. So what's in front of you right now will not satisfy the requirement to split these lots to go back to zoning. If you got approved here to go back, they're still gonna ask you for those lots of record, which they've said you don't have right now. Doing a definitive subdivision would solve that part of it. But you can't do it through this process right now because this is not a definitive subdivision application, unfortunately.
I'm sorry, Evan, I thought that it was a definitive subdivision.
This is a return to ZBA application.
Right, for a definitive for a subdivision.
They're two separate ones. That was one of the issues the zoning board had, was that they didn't feel that the lot that they were coming to the zoning board with was two separate lots. They felt it was one lot.
That's right.
Right. So in order to solve that, they would have to go through the definitive subdivision process, but they just haven't done that yet. I think there's been a little bit of confusion over overlapping processes.
I think Evan's right on that. I think Attorney McCluskey felt like the recording the deeds would satisfy that requirement of creating the lots. I understand what you're saying, Evan, about the needing to go through the definitive process as opposed to just creating the deeds. So that being the case, Madam Chair,
Mhm.
I'm just receiving a bunch of texts from Attorney McCluskey who can hear us but can't talk, which sometimes is a good thing. But good thing we can't hear him now, I'm sure. But I think based on that, Madam Chair, and I certainly hear what Evan's saying and what he feels like is the proper procedure. But if I may, and I hate to waste the board's time, I'd really like to just ask a continuance so Attorney McCluskey is comfortable with that, and I'm not making the legal decisions for my client, Madam Chair.
Okay, is there a motion for a continuance?
Motion to continue.
All right,
Second,
all right. Matthew,
Yes.
James,
Yes.
Marty,
yes.
Rolando,
Yes.
Tony, yes. All right, thank you,
All
Scott.
right. Thank you for your time, folks. I think that is it for me.
You're
Have a
welcome.
good evening. Thank you.
Thank you for that
Thanks, Scott.
information, Evan. That was helpful.
Of course.
I think that closes our agenda. Is there any other business? I think there's one plan for the board to sign, board members to sign. I've signed today. Don't think Isaiah got that email out yet. And did we get the sign-in sheet for tonight?
Oh, now you
Hey,
made it,
there
Attorney
he is.
McCluskey.
Oh, man, you want to talk about anxiety?
You can worry about it next month.
So I've been listening to the meeting and I'm telling you, I've been trying to get on this for the past 45 minutes. Evan, I think is it okay for me to speak or not right now?
We've already continued it to next month. Isn't that what you wanted?
Well, that's because I couldn't get on, but Evan sent me another link and here I am. So
Okay. All right.
I'd
Is
say
there a motion to allow this applicant to, I guess, present?
Yeah, I
Yeah.
make that motion.
Okay.
thank you very much. So members of the board, little background and history on this. We came before the Board of Appeals to divide the property into 3 lots. And this has been basically a traditional way of doing it for many years. And I've been before the Zoning Board of Appeals for at least 40 years. And Attorney Christopher Vail in my office presented the case that night, and Mr. Galligan stated that he actually raised a case that came up back when Jack Eunice was the mayor about running descriptions and turning lots into one lot, which is all fine, well and good. But nonetheless, over the years, the board continued to allow us to take one lot, present a plan to the Board of Appeals, and to then divide the lots. And then we'd go to the planning board and we would go through the process and divide the lots, and out would come 1 or 2 new lots. Well, that night, which was about a year or so ago, and we've gone through a lot with the city, Mr. Galligan stated that, well, we can't do that anymore. And the long and the short of it, and I think Mr. Sweeney was probably on the board at the time and remembers that Mr. Galligan said, we can't do that anymore, so therefore let's deny him. Well, that somehow didn't sit too well with me. I decided to try to convene a meeting with the city solicitor's office, the planning board, zoning board of appeals, and we all met at City Hall quite some time ago now, over a year ago. At which time, out of that meeting, and it was subsequent, but we never got anything in writing. The city solicitor, Megan Bridges, stated that we could create the lots by deed, which we did. And in this case, we created 3 lots, and they're on record, and you have those in your filing. So we created the lots by deed. We've made a substantial change, and we've done exactly what the chairman of the Board of Appeals has asked us to do. So now we come before the planning board. And I did hear, before I was frantically trying to call Scott Faria, who's been texting me back and forth. I did hear that from the city solicitor that we could create these by deed. Mr. Chairman of the Board of Appeals agreed that we create these by deed. We created the deeds. We recorded separate deeds. We now have 3 separate lots. Evan mentioned something about subdivision. That was not part of the city solicitor's decision. The city solicitor's decision was create them by deed. We did exactly what they asked us to do. Now, we get to the next point, which was I think that we could all agree that there's been a substantial change in circumstances such that under the statute says if you have a substantial change in circumstances, then you can go back to the Board of Appeals. With all due respect, Mr. May and the planning board rely upon it's sort of just a basic boilerplate decision that the Board of Appeals makes. And in this case, they said, we didn't have separate lots. Excuse me. We didn't have separate lots. And their boilerplate language is, we didn't have hardship. So what you're hearing from the planning members, the planners tonight, is that we still haven't shown any hardship. And I'll divert a bit to the last time I came before the planning board. And I had a similar case, and Mr. May said, lo and behold, you've got a substantial change in circumstances, but you don't show a hardship. And then you denied it. Maybe with not too much wisdom, I said to the board, that was a poor decision. I'm sure you all remember that. And I meant that in the sense that you're not applying the law. And in this case, so what I did in that case, and that was the Intervale Street case, I filed a lawsuit against the city of Brockton. And in our first meet and greet, it's called the Case Management Conference, in the permitting session of the land court, the city solicitor agreed that we should send it back to the Board of Appeals based upon what the planning board did. But not only that, but the land court judge took that one step further, and he effectively granted, without me filing a motion for summary judgment, he effectively granted a motion for summary judgment against the planning board and sent the case back to the zoning board of appeals. Lo and behold, that case has now gone back to the Board of Appeals, and yesterday was the end of the appeal period, and that case has been approved by the zoning board of appeals in the city of Brockton. And that's a case that the planning board said could not go back to the Board of Appeals. So with all due respect, and nobody likes to file lawsuits, but that's how we protect ourselves. That's how we protect our clients. And when we do that, And when we did it in the last case, it's the same situation here. The planning board cannot. And I'm telling you that when I saw the judge, basically his head snapped when the city solicitor said the planning board wanted us to show hardship. The judge was like, that's not what happens here. We show a change in circumstances. We're showing a change in circumstances in this case. We don't have to show the planning board hardship because that's the job of the zoning board of appeals. Why would you have two boards determining hardship? It's nonsense. That's not the way it works. So what I'm respectfully asking you to do is to recognize the fact that there's been a change in circumstances in that we have followed to the letter of the city solicitor's office the directive to record the deeds, which we've done. That's a substantial change in circumstances. And we've met our burden. Let us go back to the Board of Appeals. Why torture this? And why make us go time and time again? It's really a fiction. I mean, I can't tell you how disappointed I am in Mr. May in pursuing in the planning department. And I don't single out Mr. May because my friend, Mr. Sears, is doing the same thing this evening. And I honestly think that this whole thing about subdivision approval, it's just, there was a case last month in front of the Board of Appeals that the petitioner came in with a subdivision approval, and the chairman said, not good enough. That doesn't cut it. You have to divide the lots. We've divided the lots in this case, and the Board of Appeals has approved it. So with all due respect, I'm sorry, the Board of Appeals approved something different, but it was the same principle. So we've shown our substantial change. We're asking you simply to let us go back before the Board of Appeals. What's the big deal here? Where this is not something, if anything, the planning board and the zoning board should get together and sort this out and not leave the petitioners hanging, not leave the people who want to spend money in the city of Brockton hanging, not let the developers hanging. This is something that needs to be done internally, and we'll follow that process. But right now, city solicitor has issued her ruling. We've divided the lots, we've recorded them. It's a substantial change. End of story. We don't need to show hardship, and the land court 2 months ago agreed with me.
All right, thank you, Attorney Cluster. I also want to say thank you for being respectful and professional during this presentation, because the last time you were very upset with us and it didn't come across very nicely. I want to ask either Evan or Mr. May, do you know the outcome of this lawsuit?
I missed that. I'm sorry.
I'm asking Mr. May or Evan if they have the outcome of the lawsuit that you filed, if they're in the know about this.
Yes. So let me just clarify what that was. This was the 30 Intervale Street that was originally denied at zoning board, came to planning board for a return to ZBA, and was denied here as well. That decision that remanded this case back to the zoning board didn't actually mention the planning board at all. It was strictly talking about the original decision given by the zoning board. And Attorney McCluskey, your argument originally was because that might have fallen under the Dover Amendment, which is basically exempts certain uses from certain zoning restrictions. So they remanded it back to the zoning board to basically reconsider their original denial. So just want to clarify that wasn't them overturning or disagreeing with the planning board's decision. That was disagreeing with the zoning board's original decision. Because again, nowhere in that, I read the whole decision, and nowhere did it mention the planning board once. So it's my understanding that the original denial for repetitive petition to return to ZBA was okay.
May I reply to that? Ms.
Sure,
Gonzalez?
yes.
So the decision that you make tonight, there's no appeal process. So we have to be creative. And what we did is that we sued not the planning board, but we sued the city of Brockton. And in the permit division of the land court.
Sued the city for what? What?
Well, we laid out all the facts. And we said, we brought it all through, and the crux of the whole complaint, which Mr. Sears doesn't mention, and I don't know if he's read it yet, but the crux of the whole complaint was that the planning board did not have the authority to impose hardship. And I think you could probably see it online. The judge basically, when we talked about the planning board and that decision in that case management conference, and it was brought up that the planning board decided that they had the authority to decide on hardship, the judge's head snapped and he was like, what? And yeah, okay. Mr. Sears is, by the way, he's reading, there's a 2-paragraph decision sending this back to the Board of Appeals. He didn't mention the planning board, didn't need to mention the planning board. He just said, I'm sending it back to the Board of Appeals. It came from the planning board. So Mr. Sears is being a little bit disingenuous about telling you what the case is all about, because this case was about the planning board's refusal to allow us to go back to the Board of Appeals. And if you want to have time, I'd be happy to send you a copy of that complaint. And I'd be happy to, obviously you haven't seen the decision of the land court judge, but he effectively granted a motion for summary judgment on, on the planning board's failure to allow this to go back to the zoning board of appeals.
All right, thank you.
Madam Chairwoman, could I just say something?
Sure, I was just gonna ask.
Oh, go ahead.
Marty, so if the lot is divided, that does change the lot shape.
Yes.
Okay, all right. Go ahead, Marty.
I just want to ask Attorney McCluskey, because I remember that case well, and I remember your frustration. So that's one
Sorry.
case, and this one case, and this is a second case, where you're saying that the planning board is doing the same thing. So what I want to know from somebody is, what do we have the authority to do? Do we determine hardship, or does the zoning board do that?
I guess that's gonna need a meeting with the city solicitor, our attorney. Evan, if you could organize that for us, please.
Madam Chair, if I could, just a bit here. I think part of the original decision was you couldn't attach variance to something you don't have a lot for. So that's why I think in part was kicked back. So you have to attach a variance to a deed. So I think just, for anyone's
You referencing this 37 Lawn Street or the lot?
37 Lawn Street. So I believe, knowing that, I believe that was part of the original decision, if my memory serves me correct. It's been over a year, but I think that's part of the issue, was not having the lot independent.
Correct.
But now it is.
But now it is.
Right, okay. Any other questions from board members?
Yeah,
Okay.
can I make a motion?
Well, we gotta open up to public, right?
Oh, okay. Yep.
Okay. Is there anyone raising their
Uh,
hand?
Members of the public, if you'd like to make a comment, please hit the raise your hand icon on the bottom of your screen, or hit *9 if you're on a phone. And do not see anyone's hands going up, so I think you're good.
All right. Is there a motion?
Yeah, I'd like to just say one thing, Madam Chair, before I make the motion. One thing Attorney McCluskey said that really strikes me is we kind of in Brockton over the years have had a reputation of holding people up And I don't think that's right. I agree with what he said about developers and homeowners, and sometimes there's a whole lot of red tape, and it's not fair to people, and it's not good for the city. So my motion would be to let this go back to zoning board.
I'll second.
All right, roll call. James,
Yes.
Yolando,
Yes.
Marty,
Yes.
Matthew,
Yes.
Tony, yes. All right,
Thank you very much.
thank you.
I'm glad that we maybe straightened out some things tonight. I appreciate it.
So
I apologize for my frustration the last time I came before you.
I appreciate that very much. All right. There's no other business. There is a motion to adjourn.
Motion to adjourn.
Motion. Second.
All right, James,
Yes.
Yolando,
Yes.
Marty,
Yes.
Matthew,
Yes.
Tony, yes. All right, good night, everyone.
Good night. Thank you.
Bye-bye.
Good night.